A good evening, everyone, and a very warm welcome to the fourth instalment of 42 BR Barristers Civil Fraud Series. My name is Paul Fuller, and I'm joined today by Andrew Carter. Andrew and I are both barristers at 42BR, practicing business and property law. Andrew was called to the bar in 2018. And before that, he had a career practicing as a lawyer in his native Australia, and then as a solicitor at Her Majesty's Revenue and Custom, tackling, amongst other things, tax fraud. I was called to the bar myself in 2021, and before that, I had a career spanning a little over 10 years as a litigation solicitor, first of all in London's West End, and then heading up a dispute resolution department in a regional firm in London and Kent. Just a little bit of housekeeping before we start. If you have any questions today, then there should be a Q&A box that's there. Feel free to put those in there and we'll address those at the end of the session, time permitting, of course. If not, or if you're watching this session by recording, then please feel free to email us at the email address events@42br.com. Following this session, an email will be sent out with the recording and a feedback form will be circulated over the next few days. And the recording will be available also on 42BR's website and YouTube channel shortly. Now, of course, in the legal sense, the word property comprises more than just real property, that is buildings and land, and also includes personal property, that is chattels, and even at common law, things like choses and actions. And when Andrew and I were first asked to host this webinar, we thought that we would adopt the wider concept of property and try to cover fraud as it relates to property, real, personal, legal, and equitable. We soon realised, though, that given we have just over an hour, perhaps that was a little overzealous, and so got to thinking about what most would be of most use to you, our professional colleagues, many of whom will come across real property issues, that's issues relating to buildings and land, in some capacity or another, whether that's as a transactional lawyer or indeed as litigators assisting lay clients, or indeed your professional colleagues as and when things, or if and when things don't quite go as they should. And so with that in mind, today we've decided to look at some of the areas that are most susceptible to fraud in the context of real property transactions. And as a reminder, when we talk about fraud in the civil context, we're talking about a generic term, really, that encompasses a whole host of concepts. But in very general terms, what we mean by civil fraud is that where one party gains an advantage or injures another through unlawful or dishonest or otherwise improper means. And today we're going to be focusing on registration fraud. I'll be talking a bit about that. Andrew will be talking about mortgage fraud, and we'll both be talking about steps that can be taken to mitigate risks in these areas, steps that can be taken if we're caught out in these areas, and our own professional exposure in those concepts. And along the way, we'll be looking at some of the key cases and lessons that can perhaps be learned from those cases. Starting off then with some basics and a reminder perhaps of some of the checks and balances and due diligence that any practitioner dealing with the disposition of an estate and land should go through at the outset of the matter, and should also keep continually under review as a matter progresses. And yes, this is basic stuff, but therein often can lie the problem. Often this stuff is so routine and so commonplace that it can become a bit tick box, a bit tokenistic, and busy practitioners with high volume caseloads and demanding clients, and we all have those, it can become commonplace. And that can mean that the importance of these basics can sometimes only be brought into sharp focus when things go wrong. And often, of course, that's too late. And even contentious practitioners, that's litigators, dispute resolution lawyers who are perhaps not involved in day-to-day transactional matters, should be aware of these basics, because often that will be the starting point when we're examining a matter and asking questions along the lines of what's gone wrong, how has it gone wrong, why has it got wrong, and of course, importantly, who is responsible. In the majority of cases, property fraud is commissioned through some form or another of identity theft. And the Law Society has produced a very helpful note entitled Property and Registration Fraud. If you haven't seen it, I commend it to you, and we'll make that available in the materials that are available after this workshop. But the note observes that, amongst other things, those carrying out property fraud might purport to be a conveyancer or or legal practitioner working for an authorised practice. So if you're instructed in a matter and you don't know the conveyancer on the other side, then it's important that you do firstly check out their details. Are they an identified registered individual within a conveyancing practice? And are they part of a registered professional body? Conveyancing firms can also be impersonated, and we see things such as fake letterheads, fraudulent websites, false email addresses. So do take time to check these, look out for any irregularities that should be investigated further. By the same token, then, this means that your own firm could also be impersonated. So, should you receive communications in relation to a matter that you don't recognise and you can't find it on your case system, then consider again investigating that further and potentially reporting it. One common fraud that we see increasingly these days is where bank details are intercepted and changed so that payments are diverted to a fraudster's bank account. So bank detail communications should be checked and verified with the other side. And this can be done through, amongst other things, services such as lender exchange, or simply by transmitting a small sum of money in the first instance as a test to make sure that it's going to the correct recipient. In terms of your own client, if they're selling a property, then do obtain evidence that there's a clear connection between your client and the property that they're purporting to sell. And some particular clients may suggest an increased risk in these types of cases. For example, if a client only provides contact details in the form of a mobile number and or an email address, or if you're acting for multiple clients, but you only meet one of those clients and all your communications with the other clients are via email or other remote means, or where the property that's being sold is not where the client is residing, those potentially are higher risk cases which perhaps require a bit more scrutiny. You can ask in particular where your client doesn't reside at the property further questions to ensure that there's that connection between the client and the property. For example, do they have insurance documents that have a policy in their name for the property, for example? Have they had any works or repairs carried out and invoices, again, made out in their name for the property? Do they have any original plans in respect of planning permission and building regulation approval at the property? Or is there any other documentation that you can think of that you might expect an owner of a property to have, notwithstanding the fact that they don't live there? And of course, these are checks, as I said, which should continue throughout the transaction. It's not just a tick box exercise at the beginning of the matter. And one should be continuing to ask, is there anything suspicious or unusual that I need to be aware of here? So be aware of changes in a client's contact details, perhaps a client's bank account. And is there any inconsistencies between the information that the client is giving you and information that's coming back from third-party sources as the matter progresses? Her Majesty's Land Registry has identified certain categories of owners and property that might be more susceptible to registered title fraud. So HMLR is of the view that clients that are particularly at risk here include sole owners, elderly clients who may be in care or in hospital, owners that live abroad, owners that no longer live in the property because of perhaps a breakdown in a matrimonial relationship or partnership, owners whose property is simply empty, where the property is let to tenants, or indeed deceased owners. In addition to that, overseas clients potentially present difficulties from a due diligence perspective. In those cases, it's worth considering having any ID documents that you obtain from your clients signed off by a notary public in the jurisdiction where your clients are based. And in the case of corporate clients, again, there has to be further due diligence that's carried out there. Establish that the corporation exists by checking the relevant companies register. Establish who the officers of the company are, make sure that you obtain ID for the officers of the company, make sure that they have authority to give instructions on behalf of and bind the company. And again, if you're dealing with foreign corporations, then it may be worth engaging the services of a local lawyer in that jurisdiction who's independent, not an in-house lawyer, to provide relevant checks. So how about if, notwithstanding having done all of this, things go wrong? Well, from the land registration perspective, there's effectively two parts of the Land Registration Act 2002 which could potentially be called in aid. The first is Schedule 8 of the 2002 Act, which provides that where any person suffers a loss as a result of, amongst other things, rectification and need to rectify or alter the register, then the Land Registry can pay an indemnity or can indemnify the person that suffers loss. But paragraph 5 of Schedule 8 provides that no indemnity will be payable where the loss is a result of the claimant's lack of proper care. And it goes on to point out, and there's case law to establish this, that where that lack of proper care is attributable to the claimant's legal representatives, then the same principle applies. There'll be no indemnity payable. I mean, it's easy to see how that can then come back and land on your desk. The other part of the 2002 Act, which we're going to look at in a bit more detail, is Schedule 4, which makes provision for the alteration or rectification of the title register in a number of cases, including to correct a quote-unquote mistake, to bring the register up to date or give effect to any estate, right, or interest which is accepted from the registration. If the court or HMLR finds that there is a mistake on the register, or that it's not up to date, or that there's been an omission, then it can alter the register or make an order in the case of the court for the alteration of the register. And in the context of property fraud, we're mainly interested in the concept of a mistake because although the term mistake is not defined in the legislation, we know from the case of NRAM Limited and Evans 2017 that the key test for whether or not there should be an alteration of the register is whether, had Her Majesty's Land Registry known about the true facts at the time, it would have done something different. And there's a long string of common law authorities which tell us that the concept of a mistake can therefore, and does in many cases, encompass entries that are made as a result of fraud. So some examples of this include where the register is altered as a result of a forged or otherwise void transfer or other document. And the authority for that is Akar and Slough Borough Council. That's a 2019 case. Where there's been an alteration of an entry in the register as a result of a fraudulent claim for adverse possession. And your authority there is Baxter and Mannion. That's a 2011 Court of Appeal case. Or the reversal of a transfer of land by a company where the officers who were given instructions in that case, it turned out, didn't have authority to bind the company. And in that case, the authority there is Knightsbridge Property Development Corporation and Ibrid SL. That's a High Court case from 2017. Rectification is a special class of alteration where the alteration in question would prejudicially affect the title of a registered proprietor. And the general rule is that in the case of rectification, unlike alteration, that can only be done with the registered proprietor's consent. And it's easy to see the general policy reason there. Why should a registered proprietor be prejudiced? Now, often, of course, fraudsters will use dishonest means to put themselves in the position as the registered proprietor of a property. And of course, the chances that a fraudster will subsequently voluntarily consent to a rectification of a register is vanishingly low. So that raises the question, well, how is this problem to be overcome? And the general answer there is that the general rule is that a proprietor's consent is required in cases of rectification, subject to consent not being required, where the mistake is a result of the proprietor's fraud or lack of proper care, or where it would be unjust for any other reason for the alteration or rectification not to be made. And that's paragraph 3 in Schedule 4 of the 2004 Act. 2002 Act, forgive me. In the case of Fitzwilliam and Ritual Holding Services, that's a 2013 High Court case, the High Court decided that the claimant retained beneficial interest and remained the beneficial owner of the property following the sale of that property without his consent. As a result of fraud, he was entitled, therefore, to have the register altered. And in that case, Mr. Justice Newey held that the, quote, statutory magic of registration under the 2002 Act vests only on the legal title, but not the beneficial interest. And again, it's easy to see the policy consideration behind that decision, in which the High Court in that case applied the dictum of the Court of Appeal in Mallory Enterprises Limited and Cheshire Homes. That was a 2002 case. Now, Mallory had previously come under some significant criticism from academic commentators that felt that the dictum in that case, which, as I say, was followed in Fitzwilliam, flew in the face of the fundamental objective of the 2002 Act, which was neatly summarised in a Law Commission report number 271, which states that the register should be a complete and accurate reflection of the state of the title of the land at any given time, so that it's possible to investigate the title to land online with the absolute minimum of additional inquiries and inspections. So it's easy to see the tension there between the dictum in Mallory, which was followed in Fitzwilliam, and the intended purpose of the 2002 Act. But for now, at least, Mallory remains good law. So far, so good. But the paragraph 3 of Schedule 4 of the 2002 Act goes on. If any proceedings the court has power to make an order, it must do so, quote, unless there are exceptional circumstances which justify it not doing so. So the question then, again, for us practitioners from a fraud perspective is, are there any exceptional circumstances which would be a bar to relief otherwise available to victims of fraud under the legislation? And the short answer to that question is yes, there are such circumstances. For example, in Rashid and Nasrullah, that's a 2018 Court of Appeal case, the registered proprietor argued that he was in adverse possession, which was an exceptional circumstance capable of defeating the former registered proprietor, the claimant's claim for rectification of the title. And the Court of Appeal accepted this argument, effectively holding that adverse possession trumped the claimant's claim to rectification of the title, notwithstanding the fact that the proprietor had gained title through dishonest fraudulent means. In Antoine and Barclays Bank UK PLC, that's a 2018 Court of Appeal case, the court held that registration based on a court order said to have been obtained by reference to forged documents was not a quote-unquote mistake, but was akin to a voidable rather than a void transaction. And the key distinction here is that where a disposition is voidable as opposed to void, then alteration and registration will not be available. They're only available in relation to void transactions, and that's transactions that are tainted by fraud or any transactions in which you're seeking to have the register rectified. If a transaction is merely voidable, then it would have to be set aside or rescinded and thus rendered void before the relief under the 2002 Act is available. In Dillon and Barclays Bank 2020, that's a Court of Appeal case. A charge was entered onto the register of the property following fraudulent transfers. The proprietor in that case applied for alteration, but the court found that if it had have given alteration, that would have put the proprietor in a better position than she would have been if the fraud had not been committed. And on that basis, that was considered to be another ground for refusing the application. So what we see from this slew of cases is that there are situations, a number of situations in which, notwithstanding the fact that a disposition is tainted by fraud, it's not automatically the case that the injured party will be entitled to relief under the 2002 Act, whether be it in the form of an indemnity and or an application for alteration or rectification of the register. And of course, that can have potentially significant ramifications for our clients, but also for us as legal practitioners. That I know is one of the things that Andrew is going to go on and consider in the second half of this webinar. So on that note, that's about enough from me. And without further ado, I'll hand over to Andrew.
Thanks very much, Paul. So as Paul identified it earlier, I'll be speaking about mortgage fraud. And similarly to what Paul said, when we speak about mortgage fraud, what we really mean is simply using dishonesty to obtain funds from a lending source. And of course, fraud can come from all over within a mortgage transaction. For example, where the fraudster impersonates the vendor, or the fraudster misrepresents that he is a solicitor with instructions from the real vendor, or there's misrepresentation about the value of the property. You can also have mortgage fraud in the context of husbands and wives, or some collusion between vendors and purchasers, or where a purchaser misrepresents their income in order to obtain a greater advance than the lender otherwise would be willing to give. It's in that context of the ready availability of fraud within mortgage transactions that due diligence is so important. In terms of the key causes of action, usually the fraudster, if successful, has disappeared along with the money, and so the claimants are then left typically with claims against the professionals. So typically we're looking at breach of trust and acting in breach of authority, breach of a warranty, and that can take various forms. So that's, for example, to obtain a first legal charge, or to obtain signatures, to value or appraise a property, or a warranty that the solicitor has instructions from the real vendor. In addition to breach of warranty, you have breach of undertaking, which often goes hand in hand. But there are certain other causes of action that might be available. For example, misrepresentation. Is the lender on notice as to some misrepresentation potentially between husband and wife? What about non est factum, which is typically only available where there's a question around capacity, for example, blindness or illiteracy. But those are potentially causes of action that might be available. But this evening I'll be focusing on breach of trust and breach of warranty, and the remedy under Section 61 of the Trustees Act. But before we get to that, what are the warning signs typically that a fraud is on foot? Well, the BBA has issued a guide called Mortgage Fraud Good Practice Guide, which sets out a range of very good practical tips. And I think importantly for us, the annex to that guide includes some indicators that the SRA has identified as indicators of fraud. They include the failure to respond to correspondence or a delay in responding, the late registration of charges or payment of stamp duty, the failure to undertake proper or full searches, that where deposits are paid directly to the vendor as opposed to the vendor's solicitor, where there's back-to-back sales not reported to the lender. The list goes on. I think one of the clear ones for me was cut price conveyancing. If you're dealing with someone who's doing it on a bargain basement rate, that might be something that gives you some pause for concern. I think it's also important to consider the attitude of the person of your client to ordinary checks of identity. Are they resistant to in-person meetings, or are they difficult to get a hold of? Are there undue delays in obtaining documents which ought to be readily available? And we'll see from some of the cases that I'll come on to, does the office of the solicitor acting for the vendor actually exist? Are they registered with the SRA? And how satisfied are you with the responses that you're getting to additional queries? I think the key or one of the really important aspects in mitigating the risk of fraud is confirmation around identity. A key recommendation is to personally interview the vendor. Where the vendor is a corporate body, as Paul has mentioned, we have to ensure that you have all the documents that demonstrate who the natural person is behind the corporate structure that controls the company. And if that means making inquiries overseas, then that's what should happen. I think additionally, if you are not personally interviewing the vendor or your client, that is a relevant matter for the need for enhanced due diligence checks under the 2017 money laundering regulations. And it's generally good practice to personally witness the signature of any document that requires the client's execution. Paul's touched on some of the guidance on identity checks, but there's detailed guidance in Practice Guide 67, which is issued by HMLR. There are general rules, some exceptions, provision for additional checks, and further practical matters for review. And I'll leave you to look at that in your own time rather than me read it to you. But turning then to claims against practitioners in mortgage fraud cases, I'll start with breach of warranty. It's important to recognise first that the claimant must prove that the defendant gave a warranty, and secondly, that the claimant was induced to enter the contract by reason of the warranty having been given. And key is often the content of the warranty. Is it to ensure a particular outcome, or that is to act as an insurance policy, or is it merely to exercise reasonable care and skill to procure that outcome? The answer to that question is always fact specific. In Cox and McQueen 1999 case, the obligation was to obtain signatures of wife in circumstances where a husband and wife sought a second charge. The facts were that a legal executive at the firm witnessed a woman come into the office and sign these documents. She thought that woman was the wife. In fact, it was another woman. it was argued that there had been a breach of warranty because the charge had not been signed by wife as the purchaser of this mortgage. But the Court of Appeal rejected that claim. The terms of the warranty did not impose absolute liability, but it was merely to exercise reasonable care and skill to procure the desired outcome. Similarly, in Davison's and Nationwide, the obligation was to obtain a first charge. Now, this was an obligation on the purchaser's solicitors. It was their obligation to obtain a first charge on completion of a transaction for land. In this case, the vendor's solicitor was the fraudster, who obviously didn't have instructions and made off with the money before completion. In those circumstances, the warranty there was no legal charge in favour of the lender at all, and the lender sued for breach of warranty because that outcome, i.e. first legal charge, had not been delivered by the purchaser's solicitor. But the court rejected that claim, finding that the warranty to obtain a first legal charge was only, again, an obligation to exercise reasonable care and skill to obtain that outcome. On the other side, where an absolute warranty was found, we have Platform Funding Limited and Bank of Scotland. In this case, a valuer had been engaged to appraise and value a particular property, and unfortunately for that valuer, he valued the wrong property, as a result of which loan monies were advanced and the excess lost. And it was held in that case that the warranty was absolute. Now, just pausing there, I think one possible through line that distinguishes cases where there's only an obligation to exercise reasonable care and skill as opposed to ensuring the outcome. Those cases where reasonable care and skill is the content of the warranty involve some third party doing something which is outside of the control of the warrantor. Contrast that with Platform Funding Limited and Bank of Scotland. In that case, it was completely within the power of the valuer to value the correct property. There's a further illustration of this. In P&P property, the warranty was that the vendor solicitors had authority of the real vendor. And in that case, the judge found that the entry into the contract was induced by a belief that due diligence had been completed by the solicitors, i.e. that the inducement into the contract was not the warranty. Accordingly, relief for breach of warranty was refused. So it's not enough simply to say, there's my warranty, there's my outcome, which is inconsistent with what the warranty said, and therefore I've got a remedy. You have to demonstrate, one, that the warranty actually guaranteed you the outcome, and two, that the client was induced by the warranty and not by some other factor. Turning then to breach of trust. As a general statement, where a purchaser's solicitor obtains funds from the lender, those funds are held on trust for the lender until they are paid over on completion, and it's paid over on condition that a first legal charge is registered. So far, so good. Trustees can seek relief from liability under Section 61 of the Trustee Act 1925 where the trustee has acted honestly and reasonably and ought fairly to be excused. And I'll come back to section 61, but a couple of illustrations of the way that the breach of trust operates in this space. So the first authority is Lloyd's, TSB Bank, and McCandon and Uden. The employee of this involved the employee of a reputable firm, but the employee was an imposter, and the real owners of the property had no idea of the sale. The mortgage monies were paid out at the purported completion, but since there had been no actual sale, the money had been paid out in breach of trust. Secondly, Santander and RA legal solicitors, monies again paid out in advance of completion. In that case, it was a day early, was paid out in breach of trust, and that was a case of a fraudulent solicitor acting where the true vendor knew nothing of the transaction. A further authority 2019 case, P&P Property, I referred to it earlier. In this case, the purchaser's solicitors had paid money away on what they believed was completion, but since the vendor had impersonated the real vendor, there had been no actual completion within the meaning of the Law Society's code for completion by post, and that meant that monies that had been paid, those monies had been paid out in excess of the purchaser's authority, and accordingly there was a breach of trust. So I think what can safely be said is, if there's a fraud such that there's no completion and monies are in fact paid over, you're likely, in fact, it's almost certainty that that is going to be in breach of trust. The question then becomes whether you're going to get your relief under Section 61 of the Trustee Act. And the burden, as I've mentioned, is to demonstrate honest and reasonable conduct, and that the defendant ought fairly to be excused. Now, some obiter from Lord Justice Briggs, as he then was in Santander and RA, what he said was, because the burden of proof is often critical in conveyancing cases, keeping a paper trail is critical, and it's unlikely that a solicitor will be regarded as having acted reasonably without it. So turning to what is reasonable conduct now, the cases are clear that that perfection is not required, but it has to be reasonable. So where in Davison's and Nationwide, where requisitions had been requested in a TR13, but were in fact provided in an OYES form, the transaction went ahead anyway, and at first instance it was held that that was not reasonable. But on appeal, the Court of Appeal said, well, you know, what was really the difference? You still had an undertaking, whether it was under the OYES form or the TR13. And if the purchaser's solicitor had insisted on the TR form having been filled in, then it would have been filled in, and the fraud would have been effective anyway. And therefore the conduct was reasonable. And what was said there, and this is caused some further jurisprudence in the later cases. It was said that the relevant failure must be connected to the loss. Now, in that case, it was found that the purchaser's solicitor had acted reasonably because, and part of the reason why he ought fairly to be excused was that the failure, such as it was in accepting the OYES form, not the TR13, would not have materially caused the fraud. The next case that I'll deal with is a case called Perun and a Court and Co. And this was a case where there had been a breach of anti-money laundering due diligence requirements. Those due diligence, the failure to comply with those due diligence requirements increased the risk of fraud, and accordingly, it was the solicitor failed to demonstrate that he acted reasonably. So, being aware of the effect of the money laundering regulations is going to be absolutely critical, and by contrast, demonstrating that you have complied with that it will take you some of the way to demonstrating reasonableness. An example of something which was not reasonable was Santander and RA Legal. I've already touched on that, where a certificate of title was issued by the purchaser's solicitors before those inquiries had been completed. And it was suggested in that case that this was common within the industry, and it was done for the purpose of avoiding delay. But the reality is that if you issue a certificate of title before inquiries have been completed, you'll struggle to demonstrate that that you acted reasonably. What has also been made clear in the Santander case is that you have to look at the conduct as a whole, and that causation or the link between causation and acting reasonably and the discretion or failure to be excused is not mechanistic. The discretion, and I'll come on to this, is not merely focused on the trustee's conduct, but on the availability of a remedy to the beneficiary. Now, it might be said, and in fact, there was some dissent in the Court of Appeal in 2019 on this, that just because a large bank is insured against fraud doesn't mean that it should be treated any worse than anyone else. But the reality is that a person who puts up their life savings to purchase a property and who loses it to fraud is in an entirely different position to a large bank who either has insurance or insures themselves. So that is effectively all that I really wanted to say. I haven't touched on breach of undertaking, but you'll appreciate that that where you have an undertaking, it's similar to breach of trust and to breach of warranty. And I think the through line on this is that it's these fraud cases that really demonstrate the wisdom and the necessity of due diligence checks, whether they arise under the money laundering regulations or whether they are simply matters of good practice recommended by the SRA or the BBA or other regulatory bodies. Now, I'll just see if we have any questions. I don't. Paul, are you aware if we have any questions at this point?
No, I've been keeping an eye. I know that Sophie is going to fire over any questions that make their way into the Q&A to us via email. I don't have anything, but it may be that people are kindly holding off whilst we finish off. So if you do have any questions, we do have a bit of time left. So feel free to put those in. Questions yet, says me. Don't be shy. We'll give you a couple of minutes. But if it is the case that Andrew and I have covered things so well and exhaustively that no questions are left, then gold star for us and an early bath for you. As I say, we'll just give it another minute there. But otherwise, all that's left to be said, I suppose, which I don't think I mentioned, and Sophie will correct me if I'm wrong about this, but I think that the fifth and final instalment in this civil fraud series takes place next month. Do look out for that, which should no doubt be advertised on our various social media platforms and the like. And once again, this video will be circulated, a link to this will be circulated in due course. And just to remind you again that if you have any questions that come to mind after now, then do feel free to pop those over in an email, events@4242br.com, and Andrew and I will give due thought to those and come back to you. Right, well, I think I've just about filled that 2 minutes. Still nothing in from Sophie. There we are. Thank you very much for joining us today. It's been good having you here, and our esteemed colleagues will look forward to again in the fifth and final instalment of next month. Good evening.